Lawyers of Reddit, what was the best gotcha moment you ever experienced? My client's house burned down from an explosion in the fuel oil tank used to heat the house. It was clearly the oil maintenance company's fault, but his homeowner's insurance from a very reputable company still refused to pay out, citing a ridiculous technicality in his policy. Essentially, the policy covered damage caused by the oil heater, but they claimed that it was the storage tank that exploded and wasn't part of what was covered. So they deny his claim, which was about $1.2 million, and then I get involved. During a deposition with the claims adjuster, I asked how she came to the conclusion that the storage tank was not a part or at least connected to the heater. She states that she relied on her quote-unquote expert witness who was an engineer. Little did she know, I had already checked this person's background. He had zero engineering experience or education. As most of you might know, you don't get attorney's fees in most cases. However, when an insurance company denies your claim in quote-unquote bad faith, now you do. Her little admission cost the company about $500,000 in fees on top of the original claim for $1.2 million. And this is why so many people try to mess with insurance companies, because they're right there trying to screw them too. Story 2. I had a former client file for bankruptcy and in connection with that case brought an action against his landlord for violating the automatic stay. In order to prove damages, he wanted to show he paid for my firm for legal fees in connection with the landlord's pursuit of rent in violation of the stay. So this former client's bankruptcy lawyer serves me a subpoena to show up at the bankruptcy hearing. He didn't ask me any questions prior, but just gave me the gist of what the objective was, i.e. verify with the court the time I spent and the cost to his client. The bankruptcy attorney called his client, which is my former client, to the stand first. He asked him questions relating to his hiring my firm to do this and that as it is related to his landlord. Apparently, that's not enough. The bankruptcy attorney wants me to verify these facts as well. I get put on the stand and I'm asked to verify the invoice. I first object to the question as a precaution since it may be a violation of attorney-client privilege to answer the question and to cover me for any claim by the bar or my former client. As predicted, the judge overrules and orders me to answer. I review the invoice answer. Nope, this is not my invoice. His attorney. I don't understand. This is your firm's logo and information, right? Me. Yes. His attorney. And you provided these legal services, right? Me. No. A very confused attorney slowly started to put together after a couple more follow-up questions that this stupid client of ours had manufactured my invoice to prove his damages. Needless to say, I could have given his new attorney the heads up, but I wasn't going to help someone who had committed perjury to the court using my name. I had represented him in a completely different matter, and this guy was trying to make some extra cash through this bankruptcy hearing. 2 lessons: tell your attorney everything, and as an attorney, make sure your client feels comfortable to tell you everything. Story 3. Cross-examining a custom home builder who had a lump sum contract, set price as opposed to cost plus, which means cost of the materials plus a certain percentage as builder fee with the homeowner. Claimed he put 20% more labor and materials in building the home than the contract provided for, and he was suing for these excess costs. I was asking him about an email with my client negotiating the price of the construction, and he volunteered that he knew he couldn't build it for that price. My head snaps up, the supervising partner's head snaps up, and opposing counsel goes pale. Dialogue was something like, me? So you quoted X price? Builder? Yes. Me? You knew you couldn't build it for that price? Builder? Yes. Me? You know the homeowner was relying on that quote? Builder? Yes. Me? And you knew the homeowner wouldn't have signed the contract without that representation? Builder? Yes. Me? And you told the homeowner's lender you could do it for X? Builder? Yes. Me? And the bank relied on that price and wouldn't have given the loan if it knew it was wrong? Builder? Yes. This is textbook fraudulent inducement and he had no idea. Builder got poured out in the arbitration award and slapped Builder with sizable punitive damages on top of it. 5 minutes of testimony sunk his case because he volunteered information without being prompted. Story 4. Perhaps not my best, but it was recent and pretty good. I represented a guy whose car stopped working in the middle of the freeway at 4 a.m. He put his hazard lights on and called 911 for help. At the same time, an LAPD cop heading to work around the same time in a police unmarked car was driving around 87 to 92 miles per hour deconstructionist. He doesn't see our guy, strikes him and causes a major 6-car collision, including overturning an 18-wheeler truck. Police arrive and take photos. The LAPD officer claimed our guy did not have his hazard lights on and he was only driving 60 miles per hour. He was trying to put some of the blame on our guy. At the deposition of the investigating officer, she doesn't remember if our guy's hazard lights were on or not. Attorney brought photos from the scene. One of the photos showed my guy's hazard lights on. We were dismissed shortly thereafter. Story 5. Not a lawyer, but when I was in the military, I was accused of something I didn't do, and I had to go to court over it. And during court, the prosecutor started to detail this investigation and how they had staked my apartment out for months. They entered into evidence a picture of quote-unquote my apartment, and when they put it up, I looked shocked at my lawyer because it wasn't a picture of my place, it was my ex-wife's apartment. A place I had never lived, never even spent a single night there. I lived in a house, she lived in an apartment. And when my lawyer was asked if she objected to the picture being entered into evidence, she replied, I don't mind them entering it into evidence as long as they change the listing of it. And when one of the members of the panel asked what was wrong with the listing, she looked at him and said, that's not his apartment. On top of this, the witness they used against me described going to my house on the night in question, and she named the subdivision where she had visited me, except that wasn't where I lived either, also wasn't where the picture they had was either. Case was dismissed, and I was told they requested the witness to return to answer questions about perjury. Yikes, when she investigates the entirely wrong house, someone's got to get fired, right? Story 6. The funny thing was, when they brought me in to question me why they had this huge folder full of their quote-unquote evidence, and I was just like, what is going on in there? And because I wasn't cooperating by confessing to something I hadn't done, they wouldn't show me what was in it. But they had to turn it over to us before court, and it was legitimately like 5 or 6 months full of entries where they had someone scoping out my ex-wife's house. And each entry said something along the lines of when they got there, how long they were there, and no contact made with the subject. So they really were at the wrong because every day for 5 or 6 months and never realized it. I have no idea why they just never tailed me home from work or something. My wife had insurance through me for my daughter, so when they updated her address in the hospital computer, somehow they also changed mine as well. But this was back when phone books were still pretty useful and my address was properly listed in the phone book. They just never looked. They just sat at the wrong house for 6 months and still went forward with the case that they had no evidence on. So all of this investigation and drama led to a court case where the entirety of the evidence against me was basically the words of 2 witnesses, one who never testified, and the other who said she came to my house to which she was never there in a subdivision where I never lived. I mean, that was one thing I really hated about the military, that they can just do stuff like this to you, but that trial never would have happened in the civilian world. Story 7. Represented a DUI client who swore up and down to me he hadn't been drinking or doing any substance. Newbie officer who had his field training officer with him in the car. Rookie pulls client over for a tag violation, walks back to the car with body camera still on. Training officer says, get him out for a DUI, and the rookie says, but he's not intoxicated, to which the reply was, do it anyway. Body cam clicks off, turns on 7 minutes later, and they're doing field sobriety exercises on my client. Client sat in custody for 3 weeks until I finally got the tape from the prosecutor and presented it to the judge. The, oh no, looks from the prosecutor and FTO when the judge saw the tape. I'll treasure that one. Judge wrote the police chief a letter saying the FTO was gone to him, and he denied every search warrant he tried to bring thereafter for being a liar. Client is hopefully still on track with his civil attorney in a lawsuit. Story 8. I worked as a paralegal and investigator on a trade secrets case involving the production of dental wheels used for grinding teeth. Company A small family-owned manufacturer in a remote area, made the best product on the market, largely due to its long-tenured employees who had worked there for over 30 years. When the founder passed, the company was sold to international Company B, but they couldn't replicate Company A's formula in their facilities. Enter Company C, who had lost a bid to buy Company A. Learning of Company B's struggles, Company C bought the old factory and rehired the original staff, successfully producing the quality product once again. Company B sued Company C for trade secrets violations, arguing that when they bought Company A, they also acquired its proprietary methods. The dental wheel was the most profitable part of Company B's operations, making the lawsuit crucial. Company B secured a temporary restraining order in federal court, halting Company C's production at the old plant. And this is where I got involved. Our firm represented Company C, and I was tasked with interviewing all the employees. One memorable interview was with a cheerful woman in her late 50s who offered me snacks, asked if I was married, and even tried to set me up with their granddaughter. Hands down, the funniest interview ever. Then she dropped a bombshell. When I asked how she learned to make the product, expecting her to say she was taught by someone, she replied, "From the directions on the wall." Silence. "Excuse me, directions on the wall?" "Yes," she said. "No one ever looks at me, but there's a board on the wall with all the instructions." I called the facility's janitor using her phone, this was before cell phones, and had him meet me there. Sure enough, covered in decades of dust and blending into the background was a board with the entire production process written on it. Unknowingly, when Company B sold the factory, they also sold the trade secret to Company C, as they had left it behind on the wall. I did some serious evidence sourcing on this case, but the highlight was capturing the moment when the 65-plus-year-old former janitor knocked the dust off the board with the instructions. My best pictures show him smiling as he removed the entire board, placed it into a paper bag, and sealed it so I never touched it myself. His "FU" expression in every shot was priceless. It was as if he knew exactly how ridiculous and yet critical this moment was. The pictures were pure gold and captured the absurdity of the situation. When we presented this in federal court, the judge couldn't stop laughing as I recounted how we uncovered the forgotten board. His laughter only grew when he opened the bag and saw the dust-covered instructions that had been hiding in plain sight for decades. It was clear we had found the key evidence to reverse the restraining order. The factory reopened immediately and Company B and Company C eventually settled. Both agreed they could use the trade secret, but neither could sell it to anyone else. However, what they ultimately discovered was even more fascinating. The older woman, who had worked at the factory for decades, had, over the years, made subtle improvements to the formula. The instructions on the wall, while technically correct, didn't quite match the superior quality these women had been producing. In the end, it wasn't just the formula, it was their experience and expertise that made the product what it was. Story 9. My brother is an attorney. He had a case where the guy said he was permanently disabled from a work accident. At a deposition, my brother overheard the guy talking about getting his house remodeled. He was already spending the money he thought he was getting. My brother drove by the house to see how much work was being done and saw the guy carrying bundles of roofing shingles up a ladder to the roof. This was before smartphones, so he drove to a Best Buy and bought a video camera, went back and recorded the guy. He had copies made and sent it to the other attorney. The guy dropped the suit and was back at work the following Monday. My brother's client didn't want to pay for the video camera. He saved them thousands of dollars. They eventually paid, but he still gets a little peeved when he talks about it. Story 10. Not a lawyer, but a legal videographer. This gentleman was claiming injuries and seeking damages against his employer after a fall at work. He claimed he couldn't raise his right arm above his shoulder because of the fall. First deposition comes along, and I'm hired by the defendant's attorney to videotape the deposition of the plaintiff. Anyone know the first thing a court reporter asks you to do in a deposition? Please raise your right hand and repeat after me. Plaintiff raises his right arm above his shoulder with ease and no sign of discomfort. Does not occur to him what he has just done. Both attorneys were looking down at their notes when this happened and neither of them caught it. The plaintiff himself didn't catch it. The court reporter looked at him and then looked at me, and her eyes went wide with realization at what just happened. 4 hours of deposition proceed where the plaintiff is instructed to show his range of motion and proceeds to pretend like he can't raise his arm above shoulder level, which he did at the very beginning of his deposition. Deposition ends, plaintiff's counsel leaves, I call defense, hiring party counsel over and show him the first 2 minutes of tape. Counsel excitedly whispers to me, "Case closed, you just saved us tens of thousands of dollars." I got a $5,000 bonus and the plaintiff's case was dismissed with prejudice. Story 11. This is so petty, I've had much bigger moments, but because of the character of the other side of this will always be my favorite. Doing a boundary dispute, a squabble over what was essentially a few inches of land, he was acting for himself. The whole "a lawyer who acts for himself has a fool for a client" thing was bang on for him. But he was a deeply unpleasant guy who thought that he was the smartest guy in the room. Part of his case hinged on wheelie bins and how prior to the boundary having been moved, there wasn't space to store a full-size bin beside the house. The fact, could clearly mean the boundary must have moved. That was the extent of his evidence. It was really thin stuff. During the actual trial, he pulled a fast one by suddenly producing an old aerial photo, ostensibly to show the boundary at the front of the property had also moved, a fast one, because you also have to disclose stuff like that in advance. You can't just sit on something relevant and then suddenly whip it out at trial with a flourish. Whilst he was making his submissions that it should be admissible, I looked more closely at it, away from the bit of the boundary he said it was relevant to, and realized that it very clearly showed a wheelie bin in exactly the spot his case said there couldn't be one. Told the judge we were happy for the photo to be admitted after all, got the other side to confirm the date it was taken, then pointed out he just completely messed up his case. That photo did him for nearly $50,000 in adverse costs. Couldn't happen to a more deserving chap. All right, score 1 point for wheelie bins, of all things. Story 12. My client was a woman working at a meatpacking plant. Her glove, they would only give her the loose kind because they were cheaper. It got caught in the machine and she lost her arm. We sued the owners of the plant for the glove issue. We also sued the machine manufacturer for failing to include the required guard. Then we sued the distributor for being in the chain of the sale but didn't really think they played much of a role. The manufacturer swore they included a handguard and said the plant owner must have used a grinder to take it off. During a deposition of the guy that owned the company, he shows up with the sale documents he was supposed to have turned over weeks before. Turns out there was a note in small print at the bottom he didn't know about that said the sale was without the handguard, which is against the law. I pointed it out and we ended up settling that afternoon with the distributor. The woman got all her medical bills paid, got money for a prosthetic, and got a bunch of pain and suffering damages too. Well, I'm happy to hear the woman got all her medical bills paid and got money for a prosthetic and a bunch of other stuff, but still, how much does it cost to replace a lost arm? It's priceless, right? And if you're feeling any one of these stories, please remember to hit that subscribe and like button for more videos just like this. Story 13. Ex-wife gave away custody of my daughter while angrily arguing with the judge. Not a lawyer. Was taking my ex to court over custody of my kid. I had compiled a 150-page dossier complete with a report from Child Protective Services since there was no maltreatment in the household, text messages, and tons of records of contempt of our previous agreement. My daughter has a court-assigned lawyer that is normal in these cases, which after reading through all the materials and talking to all the parties sided with my lawyer and I. The ex decided to represent themselves because hubris, I suppose. Before the case was heard in the hallway outside of the courtroom, she gave me an agreement she typed up which would grant me custody as well as some generous provisions for herself. I politely declined as we were confident we would be getting a lot more in trial. Case was called, testimonies in. She put on the most hilariously insane and embarrassing show for the court. In her closing testimony, she attempted to hand the judge the agreement she tried to give us. Judge refused to take it. You can't just hand him things. That's not how you submit things into evidence. I'm not reading that. She's arguing with the judge, yelling at him and losing her temper. It's nonsense. As she was spewing, she said, "And this agreement gives him custody, which is one of the things he's after." And what I assume was an attempt to show that she's attempting a compromise. My lawyer peppers in a quick statement. "Okay, so you agree for the father to have full custody?" She snaps in heated anger. "Yes, that's what I agreed to." Our side falls completely silent, and the judge, after much effort, ends her little outburst, gave his final verdict, which started with granting me custody and putting her in court-mandated therapy. She literally gave away custody of her daughter in a heated argument with the judge. Story 14. I was representing mom in a bitter custody fight. Dad wanted full custody and argued mom was an unfit parent. Mom wanted full custody because dad had a history of maltreatment towards her and the kids. Dad's lawyer was doing a good job of painting her in a bad light during his cross-examination, and I was starting to get worried. His lawyer brought a close family friend as a character witness for Dad who said the usual nice things about Dad. Then he said something about them owning chickens. I thought that was odd, so I asked more questions. I was able to get the friend to spill the beans that the dad owned chickens for illegal fighting, and then he'd take his children to these fights, and when the children were acting up, he'd punish them by forcing them to feed the chickens. And obviously, the children were terrified of those chickens. I could see the color draining from Dad's lawyer's face. Mom got full custody. So what type of bottom-feeding C-scrum can do that to their own kids with chickens, of all things? Story 15. Told the judge to shove his threats up and pay my client. The judge paid my client. While doing SSA disability hearings a few years ago, I represented a guy in a case that was back on remand from federal court. Long story short, the original administrative law judge, ALJ, didn't follow the correct procedure and denied the guy because he, quote, could return to his last work, step 4. Basically, he was granted a partially favorable decision that gave him $700 a month rather than the $2,100 he should have received. The ALJs are notorious and try to scare people out of pursuing claims. This judge apparently thought he could intimidate me and my client into withdrawing the appeal by threatening to take away all the guy's benefits. Little did he know, I'm not a fool, and I hate bullies. He started the hearing by asking my client if he was aware that he could take all his benefits away, asking if, quote, your counsel has informed you that by continuing this hearing, you may lose all benefits and owe all amounts back to the agency as an overpayment. This was completely impossible because 6 years had gone by since the original decision, and the judge could only reopen the decision within 2 years. The guy was bulletproof on this issue. Also, the job he previously did as a computer system installer was completely obsolete and physically impossible since his physical problems prevented him from lifting more than 20 pounds, and the computers he was installing during the 1980s were 50 to 150 pounds. The judge didn't think about that and clearly did not read the federal court remand notice. So, long story short, the judge says to me, Counsel, have you done your ethical duty and advised your client that he could lose all his benefits today? To which I responded by looking at my client in a full voice saying, he can't do that. Then, without missing a beat, I looked back at the judge and said, Your Honor, I have advised my client that you cannot take his benefits away. I told the judge we would waive all other procedural portions of the hearings and proceed directly to vocational expert testimony. I asked the vocational expert 2 questions. Would the prior job require lifting more than 20 pounds? And has the prior job existed as performed since 1999? She quickly answered to both, no, and then on her own elaborated all the reasons why. Total hearing was maybe 6 minutes long. The judge had no choice but to grant the original application, and the guy got $158,000 in unpaid benefits and $1,400 a month more than he had been receiving. He broke down into tears and said he could finally keep the promise to his wife to return her ashes to the beach they got married on in Hawaii. A dream he had years ago decided would be impossible. Best day of my career so far. To everyone out there struggling or with a family member struggling with the disability system, I wish you the best of luck. Unfortunately, it requires having a good judge, and in some places, that's almost impossible. The system is rigged against people, but there are some good things that happen. And yes, I represented some people that probably weren't disabled and won some. Mental health is the worst of it and where the most injustice happens. For those of you struggling with those issues, please, please, please go to therapy, take the medication, be honest with your providers, and advocate for greater care levels. Without the evidence, it's almost impossible to win, no matter how objectively disabled the person may be. I've got a bunch of other stories that are like this. This is just one that always sticks out to me, primarily due to the client's tears and sense of hope for his wife's ashes, something I'll never forget. Best of luck to everyone out there. Take care of each other. We are all that we've got. Story 16. Not the lawyer in the story, but the client fighting an unemployment claim my employer caused to be denied. We had a phone hearing that the employer didn't show up to, so I won based on that, but they appealed, saying they had, quote, video evidence of misconduct, so we had to go to an in-person hearing. They didn't show up to the first phone hearing and had to explain why they didn't show up, and they said, quote, I messed up and didn't open the letter you sent us. And my advocate, who's a lawyer's eyes just went speechless as she slowly cocked her head to look at how profoundly stupid it was to admit that. We proceeded with the rest of the hearing, and they never showed their video that basically just showed me eating lunch on my break and watching Netflix. That wasn't even the best part of it all. My advocate tore my employer to pieces and made it clear I was terminated without good cause. The company was actually trying to slowly get rid of its office to hire overseas for support. Talked to a few people after I was let go, and slowly things like people and desks started disappearing and they started hiring overseas. Story 17. I served on a jury that was deciding a medical malpractice case. Now, the plaintiff's common bile duct was cut during a gallbladder surgery, a risk she was made aware of beforehand. She was suing the surgeon who performed the operation. The plaintiff's lawyer called as a witness a surgeon who had performed this surgery thousands of times. Speaking from this breadth of experience, he told us this mistake was, quote, entirely unacceptable, and something that no competent surgeon would do. The defense lawyer got up and grilled him for a while to make it clear that this guy made bank by traveling around the country testifying against other surgeons. Right before he sat down, the defense lawyer said, by the way, have you ever cut the common bile duct during this surgery? The case was decided and the jury all but burst out laughing when he answered, yes, I have. Story 18. A woman was charged with possession of a large amount of substance. Her boyfriend was a known big-time substance dealer with a long list of priors. Her story was that 4 officers, A, B, C, and D, came up to her outside her home and demanded to know where boyfriend was. They wanted all sorts of information about boyfriend and his associates. When she refused to tell them anything, she says Officer A threatened her, including pulling out his gun and pointing it at her. She also indicated that Officer A was wearing street clothes while B, C, and D were in uniform. Officers claim she gave them permission to search her home where they found the substance. She says she never gave them any such permission and they planted and pretended to find the substances. Officer A, it turns out, had been in the newspaper shortly before the case, went to trial for various serious incidents of misconduct and corruption. The prosecution naturally assumes this woman is lying and simply trying to take advantage of the media publicity. At trial, B, C, and D testified that they were there with Officer E, not A. Once the defense theory developed a bit, the prosecutor offered into evidence a handwritten schedule logbook thing that listed which officers were working on each day to show that Officer A wasn't even scheduled to work that day. There were various reasons this log might not have been admissible, and it was never disclosed to the defense until right before they attempted to admit it. But I quickly looked it over and, somewhat to the surprise of the judge, did not object to its admission. Did not make any reference to the log until the closing argument, then showed it to the jury and told them to look at it more closely. Officer A was not listed as working on the date, but the log also shows duty assignments for the officers working. Officer B is listed as being assigned to the evidence room or some such at the station, and Officer E is listed as being assigned to a patrol car across town with unrelated Officer F. Along with various other inconsistencies in the officers' stories, this led to a very speedy acquittal. Story 19. My favorite was a proceeding that actually led to disbarment of the opposing attorney. Opposing attorney was sent discovery requests that he never responded to. Multiple emails were sent and nothing. Moves to compel and the attorney shows up furious that we file a motion and are wasting the court's time. Says we're playing games and claims that he sent multiple emails and we aren't responding. Opposing attorney produces emails that supposedly show he's been begging us to respond. After looking at the produced emails and then looking at my calendar, we see that the date and the timestamp doesn't match the day in the timestamp. Turns out the attorney doctored an email he prepared last week and changed the date but forgot to change the day. Judge was furious and chewed him out about professionalism and ethics for 15 minutes while we just sat there quietly. It was actually uncomfortable to watch. This man then gets angry at the judge and tries to say that it was his IT guy's fault. Lying is an extreme no-no for attorneys. Our legal system depends on us being honest. He was just disbarred later that year. Story 20. I represent tenants in eviction proceedings. Landlords being landlords, I have lots of gotcha stories. The most recent one was last week in a classic he said, she said case. That is, the entire case depended upon whom the jury believed. When the landlord was thrown in prior to testifying, she unnecessarily said, quote, yes, on the Bible, when asked to tell the truth, the whole truth, etc. Her testimony, however, was evasive. She avoided answering almost every one of my questions. She even avoided answering some of her own lawyer's questions. During a recess, but still in the middle of her testimony, she was seen outside the courtroom in full view of the jury, whispering with her lawyer and a family member about, obviously, what she was supposed to say on the stand. When she got back up, the first thing I did was ask her what she was talking about with her lawyer and her family member outside the courtroom. I demanded to know whether they were telling her how to answer my questions. Her lawyer objected. The judge overruled the objection and ordered the witness to answer. The witness responded, "My life is my life." During closing arguments, her lawyer tried to argue that she must have been telling the truth because she swore, quote, on the Bible, even though she didn't have to do that. That meant, according to him, that she took her oath more seriously than the average person implied. My client who wouldn't bother swearing on a Bible when not asked to do so. In my response, I agreed with the landlord's counsel that his client must take her oath to tell the truth seriously. She must have taken it so seriously, in fact, that she refused to lie under oath when her truthful testimony would have sunk her case. So instead, she just refused to answer almost every question put to her. The jury came back in about 30 minutes with a 12-0 verdict in the tenant's favor. Verdicts in my state do not have to be 12-0. In civil cases, a verdict can be reached with 9 votes. In my line of work, unanimous verdicts are rare even in the most obvious cases. Also, the conversation in the hallway was not privileged because there was a third party there. But even if the family member had not been in the conversation, I would still be allowed to ask whether they had discussed her testimony, as long as I don't ask what they said to each other. Story 21. Never posted this before. Ex-wife, ex, trying to fight ex-husband's new girlfriend, NG. NG is in her car trying to flee while X is beating on the car, blocking escape and grabbing at door handles to get in, but the doors are locked. After X briefly moves out from the path of the car, NG begins to drive away slowly. X, noticing the car starting to leave, dives onto the hood of the car, slides off, gets run over at slow speed, and breaks bones. Several surgeries later, X sues NG, alleging negligence in bumping X with the car. As I'm deposing X, she claims to have never touched the car before it struck her, never broke the windshield wipers, never grabbed the door handle to try to open the door, never dove on the hood, just yelling. I asked what NG was doing during this time, and X described NG as a deer in headlights staring straight ahead, locked in her car, both hands on the steering wheel. How did you know the doors were locked? And that one got dismissed pretty quickly. Story 22. This isn't sexy, but the criminal defense guys will like it. Client, a fry cook, has a DWI pending. The police agency, somewhat unbelievably, refuses to provide Brady material to the DA, which has a duty under the Constitution to hand it to me. Brady material, briefly, is information in the possession of the state which would tend to exculpate or mitigate the charge against the defendant. In the U.S., we all have that right. The DA more or less abdicated his duty to seek and provide it and suggested to local defense attorneys that they subpoena the chief of police at the agency, which is a university police department. I didn't think that was such a good idea, so I subpoenaed the president of the university. While that made some folks a little crazy, including the Texas Attorney General's office, the AG filed a motion to quash my subpoena, citing how busy the president was and how she can't be troubled with routine clerical matters. The court was not impressed with the motion to quash, characterizing denial of due process as, quote, routine and clerical, didn't do what the AG thought it would do. On the day of trial announcements for the following week, an attorney from the AG's office appeared in response to the subpoena to get his motion to quash granted. Before anything happened, he came up to me and asked, with smugness, "You really think you're going to get what you came for?" I smiled. When the judge asked if I was ready for trial, I said no. The state had not provided constitutionally mandated material, so I can't try the case yet. I asked the court to call my witness, the president of the university. The court nods at the bailiff, and the bailiff starts walking toward the door to call for the witness. Then the smug AG steps up and tells the judge that she's not coming, but he's here to get his motion granted. The judge gives him one of those nice judicial eyebrows and looks at me. "I need my witness, Judge. There's bad faith and unconstitutional shenanigans afoot, and my client needs the protection of this court from the executive branch." The judge seemed to agree with me and looked at the AG, who had expected to get what he wanted by virtue of his office and his truly nice suit and enviable haircut. The AG says, "Well, she's not here, but I did bring the police chief." A woman of about 40 comes in wearing a police chief's uniform. The AG introduces her to the court. She starts talking about Brady material. I object. "Hey, Judge, this is a criminal proceeding. Can we have the witness sworn?" "Yes, we can." He swears in the chief. She starts talking again. I object. "Hey, Judge, this is a criminal proceeding. Can we have questions and answers?" It means that a lawyer sponsoring a witness has to elicit testimony through questions and answers. Sustained. Then the handsome, well-dressed, well-coiffed AG went blank. He had not planned for this. He didn't know what Brady material was. He had not talked with his witness before appearing. He had never taken part in a criminal proceeding before. He said out loud, "I've never been in a criminal proceeding before," and looked to the judge for help. But all he got was another judicial eyebrow. The chief is standing there, just standing there. The AG finally asks her, "Have you provided all the Brady material to the DA?" She says, "Yes." That was his only question. Now, it was my turn. Now, every lawyer in my country is pissed at this police agency over this Brady issue, including the judge and the DA. Me? "Good morning, Chief. Can you tell the court what Brady material is?" Chief? "Yes, it's sustained written complaints against the officers involved in the case." Judge? "No, it isn't. It's anything." Me? "Judge, please don't give her the answers." Judge? "Sorry." Me? "Is there anything else that might constitute Brady material?" Chief? "No." She is so wrong that even the clerks and bailiffs are rolling their eyes. I won't trouble this comment with the whole transcript, but she did go on to swear, under oath, that she provided all Brady material to the DA over a month ago. Now, this is only a misdemeanor matter, but the elected DA and his first assistant are in the courtroom to see how this goes. Hearing the chief make this statement, the first assistant steps up to the bench and asks the court if we might not have a little break. Judge says, "Sure, maybe y'all need a talk." The chief, the AG, the DA, and the first assistant all go into the DA's office to chat. I twiddle my thumbs for a little while, and when they're done, the AG comes up and says, "Hey, we have an agreement with the DA now. Will you withdraw your subpoena?" I said, "You've been negotiating with the wrong party. The DA is my opponent and your deal with them means nothing to me. Let's get your witness back into the courtroom." He says, "That's bullcrap." I say, "We're swearing now? Cool, go F yourself." Back in the courtroom, the chief is going to testify some more. She now swears under oath that only yesterday she had learned of the existence of internal affairs files which might have the names of my officers on them. No, she hadn't known about them before yesterday. Yes, she did know about them when she swore in court that she had already given everything over. That, my friends, is aggravated perjury with the intent to deprive of my fry cook of his legal rights. And that's what the AUSA will think when I finish this case and send her the transcripts. The very idea that a police chief would say under oath that she did not know about her own internal affairs division, which would be the first stop in any chief's first day at work, is laughable. Frankly, this woman was way in over her head, but she fully expected the court to accept her lame excuses and false claims and go ahead and screw my fry cook. The trial is postponed and still hasn't happened. The DA asked the court to take documents for review in camera to determine what is and isn't Brady. I objected. That was the DA's duty. The court is busy enough without having to do the executive branch's job. The court thought this was pretty good. In the end, the court accepted the documents after I demanded the DA waive any objection to my reviewing them with the court. After all, the court doesn't know what Brady might be without knowing all the facts. I had the court acknowledge then that within the documents provided, anything that I want is Brady. If I want it, it must be Brady. If I don't, it isn't. That should be the legal standard everywhere, all the time, but at least for now, it's the standard in this case. Also, the subpoena was not quashed and the president is still on the hook to appear next time. The court wants to hear from her why the state-funded university doesn't have to comply with the Constitution. And I'm not satisfied that the documents provided are exhaustive, so we'll keep hammering at this police agency until something breaks off. The AG guy bravely did so, not having any idea what Brady material was. At that point, the judge looked at me and said, "Now are you ready? You just wanted that guy." I had to say no. I was happy to see this lawyer disbarred, but I was still worried about my guy getting a fair trial. So while it's nice that this guy might lose his ticket, we're not done yet. I'm leaving that part to the court. I want the chief. Story 23. My brother is a divorce attorney. His most memorable case, he was representing a guy in a divorce custody battle who was accused of horrific child mistreatment. Very graphic, very detailed depositions from the young kids against daddy. Things look grim. Then my brother notices the deposition transcript done by social workers under oath contains a question at the end from one of the kids. Did I hit my marks? My brother had previously tried to make it as an actor in Hollywood right out of high school, failing miserably, and decided to get into law, an altogether different form of quote-unquote acting. He wonders how little kids know about acting jargon. Subpoenas the wife's personal checking account during discovery. Sure enough, acting lessons. Deposes an extremely sketchy acting coach, and panicked coach quickly coughs up DVDs of practice interrogations with the kids. Hours of coaching the kids on exactly what imaginary things to say about daddy. He says it was his one and only Perry Mason moment in 20-plus years of practice, and dad got sole custody of the kids. Story 24. Not a lawyer, but one time I represented myself in a speeding ticket dispute. The officer supposedly caught me speeding with his radar. After he finished presenting his case, I got to cross-examine him. Now, he was pretty good about providing evidence for the radar unit's accuracy, saying that he tested the radar before and after his shift with the tuning forks the radar came with. He even had the factory certificates for the tuning forks. But what he didn't realize was that the certificates were dated 1995. And I knew that those forks hadn't been recertified and calibrated since they'd left the factory in 1995, because calibrating tuning forks just wasn't standard procedure for my local PD. So I laid all of that out and asked how he could be sure that the radar was accurate since we couldn't be sure that the tuning forks he'd used were accurate. He just kind of went on some long ramble about how he'd been using the radar unit for a long time and how it always worked well. At that point, I was feeling pretty good and I thought I'd had him. But the judge found me guilty anyway, saying that the officer's, quote, visual speed estimation was enough to convict even if the radar evidence is in question. Well, if you like these stories and learned a thing or two from them, here's more for you. YouTube thinks you're going to love this. I'll catch you in that video, and thanks for hanging with me on this one.